Did you ever find the knife or the clothes? And if not, doesn't that mean that you really don't know what the weapon was?
Well, I can just tell you, and forgive us if we go back and forth, it's just kind of how we roll. There is no evidence that we found that would lead us to any specific, even general location as to where the murder weapon or the clothes have been. And we searched. I mean, the FBI, again, to their credit, we had folks doing soil samples and so all sorts of things to try to come up with somewhere to start searching for these things, and we just never found it. So I'll let Darren speak to
that.
Yeah,
and on the weapon, it wasn't a lack of trying. Everywhere that we had evidence of where he went, based upon phone records, based upon the evidence that we had gathered, we searched that. We went there. We did searches on the ground, in the water. We did searches. We sent soil samples to try to figure out maybe where a shovel had been used. So we searched everywhere that we possibly could, but the reality is we're looking for a singular small, it's not that small, but K-bar knife, and that's it. So
that would tell you, if you've taken every movement a guy has made for months and you have done everything you said you have done to locate the unaliving weapon and you were unable to locate it, then that should have told you you're looking at the wrong guy, dillweeds.
Morons.
Okay, how was he able to avoid having any forensic evidence, such as blood transferred to his person?
Right. So the reality is that somebody can carry this out and still not get covered in blood. That's the reality of it, and this does happen, and there's plenty of studies of that. And we've had some of the world's experts that we've asked those same questions, because we've struggled with that. Why do we not find more here and there? And the reality was, if somebody has the training, if somebody has thought about it, if somebody wears the right type of clothing, that could be the outcome, and that's what we were left with.
Morons.
Just thinking of the Richard Allen confessions, did you monitor Bryan's communications?
Yeah, we did monitor it, both while he was housed in Latah County and then once he was moved down to Ada County.
How many hours of communications did he have?
We have hundreds, thousands of hours of monitoring that was done, but there was nothing of evidentiary value that was gained from any of it.
So, just so we are clear, so far you have no weapon, no other forensic, anything other than the touch DNA on a sheath, and you have monitored thousands of hours of communications he has had, and not one word that leads toward his guilt?
Morons.
Considering we hear creators on YouTube reacting to jailhouse communications of inmates every day, and we have all heard the Richard Allen confessions he made on jail calls, will you be releasing Bryan's, or are you going to give us another one of those BS answers like it's not our policy to release those?
That's a good question.
It's my understanding that the jail will not be releasing things that involve personal conversations with third parties. That ultimately would be a decision, because the recordings are in possession of the two correctional facilities or detention facilities. But I'm pretty certain Latah County Sheriff's Office policy does not allow for that, and I would guess Ada County is similar.
Was Bryan following any of the victims online?
So, trust us, we wanted that to be the case. We've looked for a link, and we have not found one. Not one.
Yeah, through the entire investigation, I think that's something that we need, that you want, is to help to understand this and say, well, what's the connection? What was the link? And so we had every resource possible, and we worked that tirelessly, both from everything from his side, but all the victims and all the members of the House from their side. So we have never, to this date, found a single connection between him and any of the 4 victims or the 2 surviving roommates.
Social media link between Bryan and the girls.
Yes, that exists.
We have never, to this date, found a single connection between him and any of the 4 victims or the 2 surviving roommates.
I don't pretend to have definitive answers. I just give you the fact.
In a case like this, the jury always would like to know a motive. Do you have any answers at all to what his motive was?
We don't.
Morons.
Thinking about all of the mainstream minions out there in particular, they have long suggested that Bryan's sister sent in a lead that led to his arrest. Is there any truth to this?
The only thing I'm really able to talk about is that we didn't get any tips or any evidentiary items from the family.
Morons.
In the new book by Vicky Ward and James Patterson, as well as the new Amazon docuseries, they suggest that Bryan met Maddie at the Mad Greek restaurant and began stalking her from there. Is there any truth to this?
But we never found any evidence at all from interviewing everybody that we possibly could, talking to every person that would have that information to be able to show that he was there or that there was a connection through the restaurant.
Morons.
Since the beginning of this case, Pavarotti has said why you knew this was a targeted attack. Can you defend your investigation and give us a clear answer why you said this was a targeted attack and prove Pavarotti wrong?
That question over to the investigators to answer that one.
Well, I think Darren and I have, the evidence suggests that there was a reason that this particular house was chosen. What that reason is, we don't know. We don't know who the target was, and we're not going to speculate on that up here today. But we can tell you that for whatever reason, Mr. Kohberger chose that residence. Perhaps it's the location, layout, we don't know. But that's, to the best of my knowledge, that's what that statement likely led to.
Morons.
Last question. Even though it was debunked several years ago, the book and docuseries has all of the mainstream morons and their minions claiming Bryan to be the online personality Papa Rogers. Is there any truth to this at all?
Right. There was no connection. There wasn't at all. We looked into every bit of it. We took a deep dive into it. We researched it. We utilized.
In black and white. Was Bryan Papa Rogers?
It was not. It was not. Thank you. We can cut that off.
Morons. Morons.
But when it comes to the Idaho murders, there is also the social media account called Papa Roger. After the kids were killed in their King Road house, but before Kohberger was arrested, a user named Papa Roger.
Morons.
That little speech that he gave, that performative aspect of that, first of all, the seminal case in the United States, okay, happens to be out of Idaho. It's a Sonia Sotomayor 2019 opinion from the United States Supreme Court called Garza versus Idaho. Thompson made this big point of saying he waived his appellate rights. The case in the United States is out of Idaho that says you can't actually ever waive your appellate rights. Okay, so that's not real. And it is the law that he can still, as the court pointed out at the end, you got 42 days to file your notice of appeal. It might breach the plea because that essentially is a contract, but now it's post-sentencing. I wouldn't be at all surprised if we see him file notice of appeal, and you can do that. And that's for direct appeal. We still have the entire habeas process, which is another way to challenge a conviction. And Thompson gave that up with this plea. He did. He knows he did. Called Garza versus Idaho.
We'll hear argument next today in case 17-1026, Garza versus Idaho. Mr. Ali.
Thank you, Mr. Chief Justice, and may it please the court. In Flores-Ortega, a unanimous court held that where, where a defendant pleads guilty and instructs his trial counsel to notice an appeal, disregarding that instruction renders ineffective assistance in which prejudice is presumed. The court reached that conclusion even though pleading guilty waives the vast majority of claims that could be raised on appeal, and even though most defendants who plead guilty do not ultimately succeed in their direct appeal. The court correctly concluded that prejudice is presumed, both because a defendant's disregard for the instruction to notice an appeal forfeits the entire direct appeal, and because the attorney then usurps a fundamental decision that rests with the client alone.
Mr. Elling, will you just describe the relief that you seek? Am I right that what you're seeking is reinstatement of the right to appeal?
That's correct, Your Honor. I think that's a really critical point because it shows that what Mr. Garza is requesting here, what petitioner is requesting, is simply to restore the bargain that the parties struck before his trial counsel usurped his fundamental decision to appeal. So all he is seeking.
But what happens to the plea bargain? The plea bargain was conditioned on waiving the right to appeal. So I can see one argument that says all we're seeking is the right to appeal. We recognize that the plea bargain goes by the boards because it was conditioned on no appeal.
So no, that is not Mr. Garza's argument. The argument would be that the appeal would be reinstatement. All the parties before the court agree that even though Mr. Garza signed an appeal waiver, that certain fundamental claims survive that appeal waiver. So when the appeal is reinstated, the plea agreement will remain intact, the appeal waiver remain intact. To succeed on an issue that is waived, Mr. Garza would have to, and we think he actually has a colorable claim in this record that his appeal waiver was involuntary. And so all he is seeking to do, maybe this is the better way to describe this. Consider two similarly situated defendants, okay? Both sign a plea agreement, both plea agreements contain an appeal waiver, both defendants instruct their counsel to go ahead and to notice an appeal. In the first defendant situation, counsel follows that client's autonomous choice. He files a notice of appeal. All parties before the court agree that an appeal will be perfected, he will be appointed counsel, he will get access to the record which would be required to identify issues for appeal and make sure that the plea proceedings proceeded in a way that is lawful and legal and that the plea is valid. And then there will be judicial review, either of the merits of the claims raised, or if appellate counsel believes that there is no meritorious issues, the process in Anders will be followed and there will still be judicial review.
But he gets to keep this was a plea agreement that gave him fewer years than he could have been subjected to under the law. And so you say there was one judge who said he wants his cake and eat it too. That is, he keeps what's good about the plea bargain and discards what's not good. That is, no right to appeal.
Well, so, Your Honor, I think a couple points in response. It's important to recognize that simply noticing an appeal, or in this case, reinstating an appeal, it's hard to see how that alone breaches the plea agreement. And so the way this happens in practice is that when an appeal waiver is signed, the government gains what is effectively an affirmative defense that it can raise on appeal. It can choose to raise it. It's not jurisdictional. It's not self-executing. The government chooses to raise it and satisfies the Court of Appeals that the issue that appellate counsel has actually raised on appeal is, in fact, within the appeal waiver, then the government will succeed and there will be consequences, potentially, depending on what the plea agreement says.
It might breach the plea because that essentially is a contract.
He gets to keep this was a plea agreement that gave him fewer years than he could have been subjected to under the law.
Called Garza versus Idaho.
Ineffective assistance in which prejudice is presumed.
All of the stacking up of things like this at the last minute, outside of the deadline set by the court and outside of the rules, further prejudice Mr. Kohberger and his ability to have effective assistance of counsel at trial.
Ineffective assistance in which prejudice is presumed.
Experts, as outlined in our exhibit, is based in Mr. Kohberger's rights to a fair trial, effective assistance of counsel.
Ineffective assistance in which prejudice is presumed.
And it's also in violation of the discovery rules, it's in violation of the court's order, and it violates Mr. Kohberger's rights to a fair trial, effective assistance of counsel, and due process.
Ineffective assistance in which prejudice is presumed.
First, I'll start with defense counsel's obligation. In any case, defense counsel has the obligation to meet its constitutional requirements of effective assistance of counsel.
That means the advantage of taking a plea deal to remove the death penalty and receive life imprisonment means that instead of sitting on death row making appeals, Bryan Kohberger can now appeal due to Garza and not risk losing his rights to life imprisonment. He doesn't have to worry about losing the plea deal and the death penalty by appealing. The key to Garza is ineffective assistance of counsel, which, as I just showed you, Ann Taylor has set up every step of the way.
At the end, you got 42 days to file your notice of appeal.
Can I be your superhero?